Hello, good afternoon, everybody. This is Dr. G.K. Kapoor, former professor, business and corporate laws with International Management Institute, IMI, New Delhi. I have started recording a series of lectures on contract law in India. And in this particular uh, area, I have already recorded two lectures. Lecture 1 was on making of an agreement or a contract, the matters which should be taken care of. And the second lecture was devoted to a detailed discussion on force majeure clause, particularly since in India courts have taken a limited view of this force majeure clause. They have not interpreted it very broadly. So many situations which appear to be impossible, they have not been upheld as force majeure. So do kindly watch the earlier two videos on contract law in India. Today I am going to record the third video, which is in relation to essentials of a valid contract. I'm sorry, this is actually the fourth video. The third video was on what is a contract and the legal requirements in relation thereto. So today is the fourth video I am recording, and we shall be talking about essentials of a valid contract. Section 10 of the Indian Contract Act enumerates the essentials of a valid contract, but the list given is really not exhaustive, and we have to fall back upon certain other sections to complete the list of elements or requirements for a valid contract. Some of the requirements are given in the very clause H of section 2, which defines the term contract. We have learned that section 2H defines the term contract as an agreement enforceable by law. Therefore, you will appreciate that the first requirement for a valid contract is that there has to be an agreement. That means there has to be a proposal and acceptance of that particular proposal. But is it that every agreement or every accepted proposal will result in an agreement and a valid contract? The answer is no. There may be occasions where there is a proposal, there is an acceptance, and still no agreement. This will happen where there is absence of consensus, CONSUS, consensus, ad idem. This is a Latin expression which translated in English means that parties must agree to the same thing in the same sense and at the same time. So, where in spite of the fact that there is a proposal and acceptance, but if parties had different things in mind, no agreement will come into being. Let me illustrate this with the help of an interesting situation. I am giving you the example of one of the old Bollywood films called Sharmili. There were two films by the name Sharmili. I am referring to the old Sharmili, which featured Rakhi Gulzar and Shashi Kapoor. In this film, Rakhi Gulzar had a double role to play. One that of the title girl, that is Sharmili Rakhi, and the other we may call as, say, Bhadkili. As the film goes, this Bhadkili Rakhi happens to meet the hero in one of the parties. Hero is an Air Force officer, and both fall in love. It is virtually a love at first sight. So much so that the hero will not marry any other girl except this Barkili Rakhi. But as the film goes, all of a sudden, Bhadkili Rakhi vanishes from the scene, and the hero goes to the verge of madness looking for that Bhadkili Rakhi. When in the meantime he happens to receive a telegram from his mother that father is seriously ill, come back immediately. Shashi Kapoor, the hero, has to rush back to his village to find that his father is hale and hearty. He had actually been called to get married with a girl which his parents had seen for him. So they want him to see his photograph at least and then meet the girl. But he totally refuses because he is mad after that Bhadkili Rakhi. Then, perchance, he has a glance of the photograph of the Sharmili Rakhi, the other Rakhi. He doesn't know that there are two girls by the same face. He thinks that, oh, she had vanished to come to the village, and the proposal is for that Bhadkili Rakhi itself. So he immediately becomes the most obedient son on the earth and tells his parents that whatever you say. Now, I do not plan to go ahead with the story of the film. My purpose is served. So, what do you think? Did he consent to marry the girl in the photograph, the Sharmili Rakhi? Or in his contemplation was the Bhadkili Rakhi? So mentally he consented to marry not the girl in the photograph, but the girl he was in love with. Law says that consent is a mental phenomenon. So we shall say there has been absence of consensus ad idem in this particular case, and hence no agreement and thus no contract. Then another requirement to make a contract as a valid contract is once again drawn from the very definition of the contract, and that is the intention of the parties must be to create a legal relationship as against an illegal, unlawful, or social relationship. I have already discussed this in detail in my third lecture on or in this series on the contract law. Now, the fourth requirement for a valid contract is that the consent of the parties must be free or genuine. When do we say that the consent given is not free or genuine? Consent shall be said to be not free where the consent has been given under coercion. 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 Undue influence, fraud, or misrepresentation. In all these cases, consent is said to be not freely given and renders the contract voidable at the option of the aggrieved party. I shall be discussing about all these four elements of free consent in details, but I am deliberately avoiding the details because otherwise we shall lose track of our discussion on the essentials of a valid contract. The next essential of a valid contract, that is the fifth one, is that the parties to the contract must be competent of contracting. According to Section 11 of the Indian Contract Act, only those who are of the age of majority, number 2, are of a sound mind, and number 3, have not been forbidden under any other law for the time being in force. For the time being in force in law means the law existing at the point of time when the contract is made. Now, who is of the age of majority? We have already learned that a person who has attained the age of 18 years is said to be a major. So 18 and above is of the age of majority. And we have already learned that a minor is incompetent to make a valid contract, and we had taken note of the case of Mori Bibi versus Dharamdas Ghosh. More details will be taken up in the subsequent lectures. Persons of sound mind. That means, in other words, those who are of unsound mind shall not be competent to make a valid contract. Now, who are the persons who are of unsound mind? The textbooks on the subject, they classify persons of unsound mind into number one, idiots. That is a born mad. And if you address somebody as a bloody idiot, that means idiocy runs in your blood. So use these expressions not as freely as you often do amongst friends. Sometimes you call your brother, sister also as an idiot, particularly a younger one. But use the expressions knowing fully well what you are referring the other person as. So, idiot being a born mad needs probably more protection than even a minor, and therefore, any contract with an idiot or by a minor, except the exceptions as are relevant in case of minors, the contract is void ab initio. Second is lunatics. Persons of unsound mind is lunatics. That is a person who is not born mad but becomes mad at a later stage, and that too not permanently. He gets the fits of madness. So there are points of time when he is absolutely of a sane mind at and at other times he is of an insane mind. So transactions which are done during insanity are as good or as bad as done by or with an idiot. So it is treated accordingly. Still another person of unsound mind is intoxicated persons. That means those who are so heavily under the influence of a drink or a drug that one is not in a position to make a rational judgment. So law should come to the protection of such a person, and the best of the protection can be given by declaring the contract void ab initio and then creating an exception in favor of such a person. Who shall be talking about the details about the competency to make a contract, of course, a little later. But then the third one, very briefly, I may talk about, that is those who are forbidden under any other law for the time being in force. Say, for instance, Income Tax Act 1961 disallows a person to bid in an auction of the properties which have been attached for realization of the tax arrears. So the person whose properties have been so attached cannot be a bidder in the event of an auction of those properties. Likewise, in case of Insolvency Act, an insolvent is not allowed to make a valid contract except for the necessities of life, and that too up to a certain amount. Next essential of a valid contract is there must be lawful consideration and lawful object. More often than not, consideration and object will mean the same thing, though there may be a difference in certain cases. What is consideration? Consideration at this moment of time we may understand as something in return being offered or given against a promise. We have already learned that agreement is defined as reciprocal promises. A promise in exchange for a promise. And we are saying consideration is something in return for a promise. So for each promise, the other promise therefore constitutes the consideration. So therefore, quite naturally, we cannot conceive or perceive of an agreement without there being a consideration. So without consideration, there cannot be any agreement, and thus there cannot be any contract. Now, still another essential of a valid agreement is that the agreement should not have been declared void under the Indian Contract Act. I have once again discussed this in details. Say, for instance, any contract with a minor or by a minor is declared void ab initio. And similarly, a wagering agreement under section 30 is declared void ab initio. And likewise, under section 56, a proposal which is inherently impossible of execution is void ab initio. Still another essential of a valid contract is what we call as certainty of meaning. That is, the terms of the proposal must be certain or capable of being made certain or definite. So if supposing X proposes to sell 100 liters of oil to Y at a particular price, what do you think? It's a valid proposal? Answer is no, because the proposal does not specify which oil, whether it is the kerosene oil, it is mobile oil, or it is mustard oil, coconut oil, which oil has not been specified. It makes the proposal uncertain and is invalid. But if, say, supposing Mr. X deals in only one type of oil and that too only one quality, and is pretty well known to Y. Now, if X makes this proposal, it is certainly capable of being made certain or definite. Next, the ninth one, as per my list, is the possibility of performance. The proposal must be capable of being performed. We have already referred about it that a proposal which is inherently impossible of execution does not result in a valid contract. If X tells Y that I'll give you $1 million if you ride on a horse to the moon, it is impossible. One may ride on a rocket to the moon, but not on a horse. It is not possible of performance. And lastly, the 10th one we shall say is necessary legal formalities. There may be certain kinds of agreements which law necessarily requires to be in writing. Not only in writing, but also to be stamped and registered under the Indian Registration Act. Say, for instance, an agreement to buy or sell an immovable property is required to be duly stamped as well as registered. So, wherever there are specific legal requirements, they must also be duly complied with. Thank you very much for watching me. We shall continue with this series on contract law in India next time. Thank you once again.